Hey, what's up guys? Today we're going to talk about access in the context of custody, care and control. Now, as you are aware, it is common for both parents to get joint custody, but for the mother to get care and control of the child. In other words, the child will stay with the mother. And therefore, access is usually granted to the parent who is not given care and control of the child, which is typically the father. So disputes often arise in the amount of access to be given to the parent without care and control of the child. That's where all the disputes usually arise. The Women's Charter, unfortunately, does not stipulate the amount of access time a parent should be given with his or her child. Section 1262B of the Women's Charter merely states that the parent, without care and control of the child, should be granted access at such times and with such frequency as the court may consider reasonable. How does the court determine what is reasonable? The court may order access evaluation reports when necessary, especially when both parents are disputing the access times. Such access evaluation reports help the court to resolve disputes over access to the child, such as how long the access should be, how frequent the access should be, twice a week, 3 times a week, Mondays, Wednesdays, Fridays, the half a day from 12 to 5, or the entire day, whether the access should be supervised or unsupervised. Now, on the issue of supervision, well, access orders are typically unsupervised so that the parent can spend time with the child without a third party present supervising the session. However, the court may order the access to be supervised in the event that one parent has been abusive towards a child, whether mentally or physically. The court will encourage the parents to work out amongst themselves the days, the time and the place for such visitation between the child and the parent without care and control. If a mutually agreeable arrangement can be reached between the parties, then this would expedite the divorce proceedings. However, if the parties are unable to mutually agree on an arrangement, the court will look at the child's needs and wishes, the wishes of the parent without care and control, his previous contact with the child, the history of the relationship between the parent without care and control and the child. For example, if a father is frequently away on business trips and stays in Singapore for only 2 or 3 weeks a year, then the court will be less likely to grant the father generous access rights. Ultimately, the court will look to the welfare and the best interests of the child in deciding the amount of access time to be given to the parent without care and control. Examples of access periods include weekday access, weekend access, school holiday access, and public holiday access. So thanks for watching this video on access in the context of custody, care and control.